first issue, we have filed earlier this week a new Brady motion. I have spoken, though briefly, with Ms. Drain Burdick about that, so she was going to find out if they have any response to it. As far as I know, let me know. We can do that. I do want to, for you though, I do want to renew the motion that we previously filed and you denied, requesting a copy of the grand jury testimony of George Anthony. As I recall, you did not deny it with prejudice. You denied it waiting to see if there'd be a sufficient predicate. Well, Mr. Anthony has testified, and he's testified twice so far in 3 days of trial. And I believe that based on the impeachments that have occurred, or that I view as impeachments, I'd ask the court to reconsider that, making available to both sides the grand jury testimony. Of course, it comes as no surprise to the prosecution because they were there. And we've not been allowed to see what his prior sworn testimony was to the grand jury. So based on the motion previously filed, I'm renewing that and requesting that you make it available to us. It would not be perhaps most professional to argue this next case without the state having seen the case that we just got produced this afternoon, so we'll bring it up another time. I have argued to you at sidebar and with the objections done that all of this line of questioning of all these series of friends about Casey's failure to be upset or anything wrong and so forth is another word for showing remorse. As a matter of law, it's not proper. I can tell you that you also recognize as quite persuasive Brother Eaton's, Judge Eaton, retired teaching book on conducting capital crimes, page 127 and 128, I can refer you to. It's very clear, Judge, that it is improper to argue absence of remorse, and I know you know that, of course, in penalty
Yes.
phase, but so I was curious, well, wait a minute, it's no more right in the guilt phase. And the case law that I just produced says that, as far as Supreme Court case of Randolph versus State. We can argue that tomorrow morning if you prefer. I realize I just gave it to them, and I don't need to play that way. The fact of the matter is that all of these questions from all of these friends going into whether she was happy or unhappy or how she looked and no changes and so forth, repeated objections and overruled, I think that it's improper, and I'll give a chance to review on that, and I will be moving for a mistrial on the cumulative effect of all of those. So that's all I can say at this time.
State prepared to argue that now. They want to wait to.
We can argue it now. Having listened to the last part, what was the first motion again? I'm not as old as you, but I'm getting there.
Let's take the lack of remorse argument based upon the Randolph case.
The case that I've been handed, at least based upon the summary, appears to indicate that the holding is that references to defendant's remorse, let's see, it says neither the juror's reference to brutal murder nor the prosecutor's guilt-based question about defendant's remorse necessitated a mistrial. That would seem to indicate that that is not grounds for mistrial. Again, I haven't just read the head notes. I would comment, however, that the evidence in this case is relevant to establish, to rebut the defendant's initial phase one claim, or claim one, that which will come up in this case at a later time, that the victim in this case was kidnapped or taken from her against her will. Both the first version and the second version. It is also relevant to rebut the defendant's sort of 3.0 version, which I should say the defense counsel's version, that this child died by accident. Clearly, the evidence of the defendant's demeanor after this period of time and the day after and for 31 days after that are certainly relevant to establish and rebut the fact that this child died as a result of an accidental drowning. The actions are completely and entirely inconsistent with that, and are relevant to show that inconsistency that the jury can find. And I believe that it's not showing lack of remorse. It may indicate lack of remorse as an aside, but its relevance is to show, to rebut the defendant's claims about, the various claims about what happened to her daughter.
Counsel may be right. Can't say rebut. And they should have saved it for a rebuttal case, not their case in chief. They've argued repeatedly there's a state of mind exception or a consciousness of guilt, and that's wrong. Because the charges here, counts 1, 2, and 3, deal with an allegation of crime committed upon the death of the child. Actions thereafter are not relevant unless they are subject to no other interpretation. We filed a memo on that. The bottom line is, if there was evidence of flight, it would come in. We know that. In fact, you get a flight instruction. If there's evidence of destruction of evidence as to guilt, that'd be admissible. Failure to respond in what someone else says is the normal way to be expected. It's not properly admissible as to state of mind, consciousness of guilt, and therefore it's not admissible. And now, in addition to that, as counsel acknowledges, it could well be dealing with remorse. It violates the rule in Randolph versus, and for the record, that's Florida Supreme Court, dated May 3rd, 1990, found at 562 Southern 2nd, 331. The particular references on that subject matter of that case are at page 7 and 8 of the copy that I provided the court.
Well, let me ask the state a very pointed question. Is the evidence being offered to show a lack of remorse?
No, sir.
Well, if it is, then it's not admissible and we got a problem.
It is not.
Well, I'm just asking you since you
Sure. made
that statement. It may indicate a lack of remorse as an aside.
Correct. It could. It's not the reason it's being offered. Whether someone would interpret it as showing lack of remorse is up to them, but that's not the reason it's being offered.
Wow.
And it won't be argued. Thank you.
Anything else, folks? Okay. The case is quite clear. You can't offer evidence of lack of remorse. I have not taken that to be lack of remorse. It shows her conduct, how she acted after these so-called tragic events. Even though opening statements is just what it is, opening statements and not evidence, the defense has laid out the proposition of the theory of defense that the victim in this case may have drowned, and then the body was disposed of by Mr. Anthony, allegedly, although we haven't gotten any proof of that at this stage. But it is relevant to show her conduct, and the jury can draw from it, but it is not admissible to show lack of remorse, so the court will stand behind its previous rulings. All right, anything else that you want to talk about now? You want to deal with the grand jury testimony?
Yes, sir. That was the other issue that I was.
Now, you want to deal with that in the morning?
Your Honor, we can deal with it now. I believe that the proper procedure at this point would be for the court to review the grand jury testimony to make a determination in camera whether there is anything exculpatory or impeaching, and I believe that's what the court can do.
Okay. Then I will ask the clerk to find out which court reporter took down the grand jury testimony of Mr. Anthony. Transmit that to the court reporting supervisor. and they are to prepare me a in-camera transcript that will be delivered to me of Mr. Anthony's grand jury testimony, and I will review his testimony.
We already have a transcript,
You do?
and we will provide it to you. Yes, we had, some years ago, requested a transcript to review for possible, for that purpose.
I don't
and we'll
remember.
provide it to you. Bring it tomorrow.
Then bring it to me tomorrow.
Yes. We do have a motion in limine. We were going to file it in writing tomorrow morning. It has to do with an in limine, basically asking the court to require the defendant to proffer any questions they're going to ask of any witness that seek to elicit hearsay statements of the defendant, so we don't have questions, objections, and but we can either, we were going to file it in writing, but the defense wants to deal with it now, we can deal with it now.
You want to deal with it now? You want to deal with it in the morning at 8:30? Turn your speaker on, please.
This is a motion in limine in the middle of trial. I don't know if, I'm certain it's past your deadline.
It's based upon certain conduct of counsel. We'll be happy to put it in writing and make it clear and concise, but it's based upon what's going on in the trial.
File your motion, and I'll determine whether it's timely or untimely, and we'll go from there.
Yes, sir.
Now, let me hear the defense's position and the state's position about working Monday. Orange County government, as far as the building is concerned, has cleared it in terms of opening the building and the costs associated with that. There is another major issue in terms of a budgetary problem for the sheriff's department, though, in terms of union contracts and overtime that will affect their budget dollars that I'm taking in consideration. And I need to know what the defense's position is, and then, or the state, either one who wants to go first.
This old veteran doesn't want to work on Monday. For 47 years since I came back from Far East, I celebrate it every year.
I don't want to say I'm old, Your Honor.
You don't, I know what you're gonna say. State?
We're trying to determine whether or not we can get witnesses. I expect that the testimony next week will involve many of the law enforcement officers with the Orange County Sheriff's Office. Right now, we don't have answers as to their availability. I don't think that there would be a problem, but there's always a possibility that people have made plans for the holidays.
Well, most people have made plans for the holidays. The original schedule that I had given you was a schedule that you would be off on Memorial Day, but you would be working Saturday from 9 to 1. At this point in time, I really don't see a compelling reason to work on Monday. But what I will be asking for at the close of business next week, Friday, but not Saturday, since you will be working Saturday, is I'm going to ask you in terms of your best guesstimate at that time, when do you think you'll be wrapping up? Okay, anything else we need to take up?
Yes, Judge, only that there are some...
Put your speaker on.
There's only some I think there's some orders that we've been waiting to be signed with you, J.A.
Well,
And,
she's
time
been
is of
out
the
for the
essence.
last 2 days because of certain family issues. I asked Ms. Sims to bring me those things today.
I
So
will
if you
bring them-
have them,
I'll have them brought first thing in the morning, Judge.
bring them in the morning and I'll take a look at them. The only one that I have seen that's on my desk, like I've been in my office all day, but I haven't, was a motion for transcription.
I'll have it all first thing in the morning.
Now, I did sign an order giving you an additional 100 hours. You had requested 200, but I cut it down to 100 for additional investigative hours. I signed that. Is there anything else besides those two?
Just JAC stuff, that's really the whole thing.
Like
Yes.
what?
Transcripts. And Dr. Crop.
Bring me the thing on Dr. Crop. The only thing I'm gonna say about Dr. Crop, let me look at it, and as long as there are JAC rates and he's not asking anything outrageous and is consistent with JAC rates, I don't see any problem, but I just need to see it.
Yes, sir.
Anything else, folks?
Nothing further.
Okay, we'll be in recess. Are you gonna take up the motion and limit it tomorrow at 8:30? Then we'll be in recess to 8:30 tomorrow morning.
If I have it finished this evening, I will email it to Mr. Baez. If not, I'll have it first thing in the morning. That's why we told them what the subject matter was going to be.
Information that they're, or what they're
Well-
relying on.
You need to, it's no big secret, we've been talking about it off and on the entire day.
Lazaro disappeared, or we never got him to proffer?
You need to make sure he comes back tomorrow so he can proffer his testimony sometime tomorrow. Let me ask you this question, Mr. Baez. How long do you think the proffer will take, since it's just going to be a proffer for purposes of the record?
30 seconds, Judge, really brief.
Okay. Well, you want to do it now, you want to do it in the morning?
We can do it now. I don't expect it to take long.
Okay, let's bring him in. Now, to the press. The defense has indicated that they don't want to do any interviews. And they claim that some people are hounding them about interviews. I have no authority over you on public property. But we have designated interview zones if folks want to participate in interview zones. Please try to respect their right not to give interviews if they don't want to, but as I told the defense, when you own public property, you own public property. And I have no control over the sidewalks of the city of Orlando, just the courthouse proper. So that's all I'm going to say about that. Okay, Mr. Lazario is here. Mr. Lazario is still under oath. Mr. Baez, you may go ahead and proffer the testimony that you wanted to give. You may proceed, sir.
Yes, sir. Good afternoon, Mr. Lazaro.
Afternoon.
I want to ask you a question in reference to the shared secrets that we had discussed earlier
Sure.
with your prior testimony. Was the secret that Casey had shared with you that she had been abused by her father?
No.
What was the secret that she had shared with you?
Lee Anthony tried to sexually abuse her.
Okay. And did you did she ever discuss in reference to, well, let me ask you this. What was your response to Lee Anthony trying to touch her?
Shocked.
What did you do, or what did you say to her?
I don't remember. It's definitely comforting, though.
And did you kind of brush off the conversation?
If anything, I probably tried to quickly change the subject so she wouldn't be dwelling on it.
And
I can't remember the exact how it happened, but I do recall her mentioning it. And from my personality, knowing myself, that's what I would be doing, trying to change the subject to get her mind off it.
And is that part, in fact, because you really don't know how to deal with something like that?
Correct.
Okay. If I can have just a moment. We're going to get the transcripts, but I want to ask you if you recall any discussions with Casey in reference to the abuse by her father.
Yes.
Okay.
That's what clarify that more would be, I do recall her bringing up being disciplined by her father, but I don't recall what actually happened. From my knowledge, it seemed like discipline to me.
But do you recall not, well, I'll need the transcript for this, but can you recall for certain that it wasn't because that it was sexual abuse versus physical abuse, or you just don't know for sure?
I just don't know for sure. Definitely was not sexual abuse. The only time someone tells me that, that's why I knew the lead thing, because that's such a substantial thing to say.
Was it a lengthy discussion or was it a short discussion?
Definitely a short discussion.
Okay. And you don't recall the details of it?
No, sir.
However, you do recall the word abuse coming up within this discussion?
I do recall the word maybe hitting.
Anything else?
No.
Okay. We're going to, Judge, we had his file outside of the, if we're getting it right now.
Okay. While you're waiting on this file, I have a couple of questions I would like to ask them. Sir, when did Miss Anthony tell you approximately about Lee Anthony's abuse?
It would be around the time that I went to New York, so either before or after, before June 30th, right around that time, or after July 5th.
Of which year, sir?
Of 2008.
With as much detail as you can recall, what did she say Lee Anthony did to her?
He tried to feel her up.
Did she say where he tried to feel her up?
On her chest.
Any place else besides on her chest?
No, sir.
Did she say what was her approximate age?
I can't recall that. Wasn't that, I can't recall, sorry.
Okay. Did she mention whether that had been recent or whether that had been in the past when she was a child of tender years? By tender years, I mean 12 and below.
It was definitely in the past. It wasn't anything present. And I wouldn't.
But she didn't attach an age as to how old she was.
No.
Can you recall anything else she said about it?
No, sir.
Now, You said, she said, he tried to fill her up. Did you inquire or did she say whether or not he was successful in filling her up?
She said it didn't happen.
It did not happen.
Yes.
So she said he made an attempt to fill her up.
Yes, sir.
Anything else that he tried to do?
Not to my knowledge.
All right, let's move on to Mr. George Anthony, her father. Would you relate to us what she said occurred in terms of abuse with Mr. Anthony, as in much detail as you can recall?
Hitting. That's all I can remember.
Okay. When you say hitting,
Hitting.
okay, what did you take that to mean, or did she give you a more specific description of hitting?
I took it as discipline.
But did she tell you, besides use the word hitting, did she say anything else?
Not to my knowledge.
Again, did she say when this occurred, Mr. George Anthony hitting her
As a child.
as a child? Anything else she said that you can recall?
No, sir.
Okay, Mr. Baez.
Mr. Lazaro, do you remember we conducted a deposition over the phone?
Sure.
And do you recall me asking you the following question, page 30, line 13 through 17? So you don't know if it's physical? Yes.
Turn on your microphone, the court recording.
This is, we only. Second deposition, sorry. So you don't know if it's physical or sexual, you just don't recall. And your answer was, I just don't recall. It could have been. Honestly, it would have been much better to do this at that time. Do you recall giving that answer?
Yes.
And
Which Anthony are you referring to with that line of questioning, Mr. George Anthony or Mr. Lee Anthony?
that was in reference to George Anthony, was it not? Okay. Yes, page 30.
That was Mr. George Anthony?
Yes.
Okay,
sir.
thank you.
Now, sir, were you referring to that your deposition took place in 2011, February of 2011, as opposed to you being asked these questions in 2008?
I was referring to it would be easier if it was asked those questions probably closer to the time that I would know that.
And that's why you simply just can't recall whether it was physical or sexual, only that you do remember as of now
No,
hitting.
of anything, any kind of abuse. That's why I was making that comment then.
Okay. I have no further questions, Judge, or no further information to proffer.
State in a cross-examination on the proffer.
No, sir.
May Mr. Lazario be excused from the state.
For the night, yes, sir.
Okay. Yes. For the night, Mr. Lazario.
Thank you, Your
Thank
Honor.
you, sir.
Thank you.
Okay, folks, anything else for the good of the order before we recess for the evening? On behalf of the state of Florida, on behalf of the defense, okay, we'll be in recess to 8:30 tomorrow morning. All right, state may proceed with their motion in limine.
Good morning, Your Honor. We filed a very brief written motion to prohibit counsel from eliciting statements of the defendant from witnesses without making a proffer to the court ahead of time out of the presence of the jury as to the admissibility of the information that would even be contained in the question. It has been our experience so far in this case that counsel has been asking witnesses things that the defendant may or may not have said to them, which is in clear violation of the Evidence Code, Florida Statute 9802. There are exceptions for certain hearsay statements. There are also exceptions that are available to the state, as the court knows, that or the party opponent, that aren't available to the defendant. And for us to repeatedly, particularly once the question is out, object to this type of inquiry when counsel's already been warned of the inadmissibility of that without an appropriate exception is detrimental, in our opinion, to our position in front of the jury. So we are asking, not necessarily to prohibit the question at this juncture, because there could be an appropriate exception to the hearsay rule, but that counsel be directed or ordered to proffer anytime he wants to ask a question regarding one of the defendant's statements.
Reply from the defense.
Yes, sir. Our first position is that this is an untimely motion. Our second position is that this is a perfectly timed motion for the prosecution, and that is, this comes now subsequent to them parading witnesses up here to talk about my clients spending the night, sexual partners, innuendos, and showing the bruise of what was on Caylee's eye. After they've gotten all this irrelevant information in through the back door, much of which it was stricken, now they certainly want to try to preclude any questions that might hurt their prosecution. I understand it's a very smart and strategical move. However, one, it's untimely. Second, it limits any type of cross-examination based on the defense. Now, certainly there are topics that are sensitive in nature, topics that may come close to being objectionable. But coming close to being objectionable and actually being objectionable are two different things. And to limit our cross-examination of a witness clearly obstructs the truth-finding process. There may be issues that can be touched upon, and we all know what we're talking about, without it actually being against any of the rules of evidence in this case. They're very capable prosecutors. They don't need an advance notice of what a witness is going to testify to. And the big fact here too is this isn't a scripted event. Many of these witnesses, we will not know certain things that they will testify to or what they may change once they take that stand. So I think to limit the cross-examination and requiring proffers, thereby allowing state witnesses to take the stand and or to give the prosecutors an advance preview of what the cross-examination is going to be, I think the defense is significantly prejudiced in that fact. Couple that on with all of the other evidence that the state has, in our opinion, impermissibly been allowed to introduce. And I think we have a theory of defense, Judge. We need to have the right to explore it, and we need to be able to have these witnesses on the spot and ask them specific questions. If there's an objection to the question, the prosecutors are more than capable for objecting, and this certainly doesn't require us stopping, proffering, and giving them an advance notice of what is actually going to be asked of a particular witness.
Okay. Chapter 90 of the Florida Evidence Code provides the framework for what evidence is admissible. Even evidence that the defense may or prosecution that may attempt to introduce evidence must meet the requirement of Chapter 90. This motion basically deals with attempts by the defense to elicit statements by the defendant from other witnesses. Those are under the evidence code self-serving when attempted by the defense. There are basically 3 exceptions to that, which I will not go into, that may permit some of these. Under those 3 exceptions, there are foundation requirements that must be asked before those questions can be asked. As of yet, there has been no attempt to establish those foundational requirements, not saying that they are admissible under those 3 exceptions. Therefore, the state's motion in limine regarding statements of the defendant be proffered will be granted. Anything else?
Yes. I wasn't sure if the state had any other motions.
Nope.
We would, at this time, renew our motion for a mistrial based on the evidence that the state has presented, the impermissible evidence of remorse, impermissible character evidence that has been numerously objected to on various levels. So far, the state has put on a case solely of dealing with the bad character of my client, or the attempted character assassination of her past conducts, boyfriends, people she slept with, things that have absolutely nothing to do with the crimes charged, and has put us in a position where we are significantly prejudiced as to some of the impermissible character evidence that they have been successful in introducing. And we would again renew our motion for a mistrial at this time, Judge.
Mr. Baez, how many times have you asked on cross-examination of witnesses whether or not Ms. Anthony was a, quote, good mother, unquote?
Many times, and
Okay.
I don't think one has anything to do with the other.
Now, just answer my question. You've asked many times.
Yes, sir.
Okay. That can be construed, Mr. Baez, as a question dealing with character evidence, which the state has objected to, and I sustain the objection. Are you familiar with the case of Greenfield versus State?
No, I am not.
Okay. It's a case that basically established a proposition which prosecutors loosely call "have you heard," when someone attempts to introduce character evidence and for whatever reason the state permits it, and they're permitted to elicit a line of questioning called "have you heard?" And if you have heard all these things after they go through a litany, do you still have the opinion that this person is a whatever trait of character? So we haven't got to that stage because the question that you ask is not a pertinent character trait, which is admissible as character evidence. But the motion for mistrial will be denied. Anything else, folks? Yes, sir. And state your name for the record, please.
William Slabaugh on behalf of the defendant, Caylee Marie Anthony. We wanted to bring to the court's attention a motion for additional hours of investigation that was heard back in March of 2011 on the 23rd day. It is my understanding the court granted that motion.
I granted, you asked for 200 hours, I granted 100 more.
Your Honor, I believe that was the most recent one. We're referring to the one back in March.
Okay, in March,
It was
okay.
argued by Attorney Michelle Medina from our office, and it was granted by yourself and entered on the court's docket. However, a signed order was never issued.
Okay, do you have a proposed order?
Yes, we do, Your Honor.
Okay.
As well as a few motions that I believe were filed while
Okay.
we were in Pinellas County for motion for transcription services for Dr. Neil Haskell.
I can't remember, I signed one yesterday evening, but if you have a copy of it.
Okay. And we also had a motion for transcription services for some motion to suppress hearings and the Fry hearings. However, the court reporter only transcribed Jordan Cindy Anthony's testimony and failed to transcribe the other witnesses that testified at those hearings.
Okay, may I see your proposed order, sir?
Yes, sir.
If you hand them to the clerk.
We had a few other additional ones.
Okay, go ahead and finish.
Okay. The other one was, I believe, filed yesterday, the day before, regarding a motion for transcription services for Clint Roy House that testified on the 25th. Feel we need those transcripts for impeachment purposes, as well as some other witnesses that were deposed earlier this year. And would I approach?
Yes, sir. Hand those to the clerk.
I apologize, Your Honor. I just realized the bottom order is for a motion for additional hours for the penalty phase for Janine Barrett. We were requesting, I believe in the motion, for 100 additional hours.
Okay, just a second. Okay, what is the purpose of the transcription, the emergency motion to preserve evidence, participate in forensic testing? Why do you need that transcript?
I believe it was going to be used for impeachment purposes.
Who testified? I think that was done in December of '08. I wasn't involved in the case
Your Honor,
then.
I apologize.
Can anybody recall who, did somebody testify?
I could research it further, and if we could address this at another time.
Okay. Motion to preserve forensic evidence. And there's a motion to suppress 911 call. I believe I did that one, and motion to suppress statements. If the emergency motion to preserve and inspect evidence, participate in forensic testing contains witness testimony of witnesses who would testify, that will be granted. I just asked the court reporting service to review those and let me know.
Yes, Your Honor.
But it's going to take some time because most of those court reporters are in this court. You don't have the depositions of Dr. Weiss and Danzinger transcribed?
I do not believe so. Yeah, Your Honor. Okay. Okay. We'll request a copy from the
Okay.
court report.
Can I do, for the penalty phase, what did you say about that, sir? For
believe we
additional
filed-
investigative hours?
Yes, sir. for 100 hours for Janine Barrett, the mitigation specialist.
She hasn't completed her investigation yet.
I believe there were some additional issues that have arisen.
Okay, thank you, sir.
Thank you.
Okay, anything else? If not, we'll be in recess to.
That type of work.
In this particular job, it's been about a year and a half now.
Do you know Casey Anthony?
I do.
How do you know Casey Anthony?
I'm engaged to Lee Anthony,
Okay, and who is Lee Anthony?
Casey's brother.
When did you first meet Lee Anthony?
Late in 2006,
And have you two been together since 2006?
pretty much, yeah.
Was there a time when you were not?
Yes.
When was that?
It was a brief period early in 2007.
In June and July of 2008, were you and Lee a couple?
Yes.
How would you describe your relationship during this time period of June and July of 2008 with Casey Anthony?
I mean, we chatted every now and then. We weren't extremely close, but we kept in touch and checked in on each other.
Do you have any issues or problems or arguments with Ms. Anthony during this time period?
Myself?
Yes.
No.
How is your relationship with Cindy Anthony?
Good.
Or how were you? Are you close to her?
Yes.
Were you close to her back in 2008?
Not as close as I am now, but we had a good relationship.
How about George Anthony?
Pretty much the same.
You obviously you knew Caylee Anthony
Yes.
prior to June of, or strike that. Were you aware, directing your attention to June of 2008, were you made aware that, or did you notice that Casey Anthony was not at the house?
Not in June, no.
Okay. How about in July?
Yes.
When in July?
Early July.
How did you become aware of that?
Lee had received a phone call from his mom stating that she,
Sustained.
Did you talk to Cindy Anthony about this?
no.
Upon talking to Lee Anthony, did you make any attempt to try to contact Casey Anthony?
Yes.
How did you do that?
Text message.
You had her phone number?
Yes.
When did you text message Casey Anthony?
It was a day or two before the July 4th weekend.
What do you recall asking or writing to Casey Anthony?
I was asking if she was downtown, in downtown Orlando,
Was this during the day or night?
night.
Directing your attention to July 3rd of 2008, did you make any further attempts to contact or find Casey Anthony?
I don't recall if that was the actual date that we were downtown, but the night that we were downtown, yes, I did make further attempts.
Okay. Who did you go downtown with?
With Lee and another friend of ours.
Okay. Who's that other friend?
His name is Danny Alvarez.
Where did you go downtown?
We went to a club on, I believe it was on Church Street.
For members of the jury, can you describe what Church Street was back in 2008?
Church Street it's a street downtown that has clubs and bars and restaurants along both sides for a good couple of blocks, so it's a pretty popular place to go when you want to go out and go to a bar or something like that.
When you and Lee and Mr. Alvarez went downtown, did you have reason to believe that Casey Anthony was downtown?
Yes.
Okay. Based upon what?
Lee had received information from friends or family.
Did you know of a specific club?
There was a specific club that we believed that she was at. I do not recall the name.
Okay. Did you go to that specific club?
Yes.
About what time did you arrive downtown?
If I had to guess, I'd say maybe 10 o'clock.
All right. And when you went to that club, did you see the defendant?
I'm sorry?
Did you see Caylee Anthony when you went downtown?
No.
During this time period, did you again try to contact her via telephone?
Just via text message.
All right. How many times do you believe you text?
I would say probably 5, maybe 6.
Okay. Did she respond to those text messages?
Some of them.
Okay. When she responded to well, first of all, what were you asking her or telling her in those text messages?
I was asking if she was downtown, just to see if we could meet up.
Okay. Did she respond that she was downtown?
No, she never stated that she was downtown.
Okay. What did she respond?
I don't remember the specifics. I do know that she did ask if I was with Lee, and then she did, through further conversation, she was basically telling me that she didn't want the family to worry about her. She just wanted some space.
Did she mention anything about Caylee?
Not directly. I asked her if she would be coming to the house over the weekend for like a family get together, and if she would be bringing the baby, and she said she would try.
She would try? Mm-hmm. Thank you.
Is that a yes or no?
Yes, I'm sorry.
How would you describe your brother's demeanor during this time period while you guys were on Church Street?
I'm sorry, my brothers?
I'm sorry, Lee Anthony's.
He seemed very focused, but also very frustrated and concerned.
While you were texting or attempting to text Caylee Anthony, was Lee also trying to get a hold of her as well?
Yes, sir.
To your knowledge, did they actually have a conversation during the night?
Yes, sir.
After exchanging these text messages, did you attempt to call?
I don't believe so.
How long did you stay downtown?
A couple hours, a few hours.
Did you stay in one place or did you go to different places?
We mostly stayed in one place. I believe we may have checked one other place before we left, but we pretty much stayed on Church Street.
Did you ever locate Caylee Anthony?
No.
After exchanging those text messages on July 3rd, did you ever exchange any other text messages with her between that date and July 16th?
I don't believe so.
Did you ever speak with her again did you ever speak with her on the phone between those dates?
I don't believe so.
During this time period, did you spend any time with Cindy Anthony?
I don't recall.
How about George Anthony?
I don't recall.
Would you be able to tell the jury anything about their state of mind or demeanor
During
July of 2008?
Objection, Judge, speculation. And you will.
If, just a second. Sustain.
Okay, may I have 1 second, Judge?
Yeah.
Thank you very much, ma'am. I have no further questions.
Cross-examination.
Good morning,
Good
Ms.
morning.
Parker. You were aware that you went looking for Casey because Cindy Anthony was requesting this, correct?
Mr. Baez?
Without telling us what was said to you.
Sustained.
Yes, I'm looking for the right words, Judge. Now, you testified under direct that the reason you went downtown is because Lee wanted to go there, correct?
Correct.
And you went there at Lee's urging.
Correct.
And it was also your understanding that the reason both of you were going there was at Cindy's urging, correct?
Correct.
And not George Anthony.
Correct.
Now, you had an opportunity to view Casey and Caylee together, did you not?
I did.
And did you ever see Caylee running to Casey?
I'm sorry, did I ever see what?
Caylee going up to Casey?
All the time.
And did you ever see Caylee's affection towards Casey?
All the time.
And how would you describe to the ladies and gentlemen of the jury of the way Caylee loved her mother?
It was amazing. Excuse me. Casey and Caylee had a very special bond.
And did it appear genuine to you, Mallory?
It did.
And did Caylee ever go without food, as far as you know?
No.
Did she ever appear neglected to you?
No.
Did you ever see Casey strike or torture or punish Caylee in any harmful way?
No, sir.
And the best way that you can describe their relationship would be amazing.
Amazing.
Thank you.
Redirect. May the witness be excused. Thank you, ma'am. Thank you. May be excused. You may proceed.
Thank you, Judge. Good morning, sir.
Hi.
Mr. Waters, how old are you?
32.
Are you working?
No, sir. Unemployed right now.
Okay. What type of work have you done?
Engineering. I was doing the speed rail project, light rail.
What about your educational background?
Didn't graduate.
Are you still living here in the Central Florida area?
Yes, sir.
Sir, do you know a woman by the name of Casey Anthony?
Yes, sir.
When did you first meet Casey Anthony?
I met Casey on the 4th of July, 2008.
Where did you first meet her?
I met her at my home. I was having a 4th of July party.
Do you know Amy Huizinga?
Yes, sir. I was working with her at Houlihan's restaurant.
So did you meet Casey Anthony through Amy
Yes, sir.
Huizinga?
Yeah, they were decorating my house when I got off work that evening.
If you recall, was this a daytime party or a nighttime party or both?
It was a combo. It was kickball during the day, and then after fireworks, drinking and.
Repeat your last answer, sir.
It was a daytime, nighttime party. It followed through. It started in the daytime, then ended at night.
Did Ms. Huizinga and the defendant come over to your home at the same time?
Yes, sir.
Do you recall about approximately what time that would have been?
Or any time after lunch is around 1:30.
When you first met the defendant, what was your, can you tell the jury what her demeanor was?
Overall.
She was polite, said hello, I'm Casey, and just regular conversation started.
Okay. When you first met Caylee Anthony, did she tell you that her daughter was missing?
No, sir.
Overruled.
Did she tell you her daughter had been kidnapped,
No, sir.
or that she was actively looking for her?
No, sir.
Relevance.
Overruled.
At that point, when you met her, did you know she had a child?
Yes, sir.
How did you know that?
I was told by Amy a couple weeks prior, and then on conversation,
Hearsay.
I'll rephrase the question, Judge.
Sustained.
Did the defendant ever tell you she had a child?
yes, sir.
When did she tell you that?
That evening,
Since this is the first time you met, did you have just a get-to-know-you type of conversation with Ms. Anthony?
there wasn't really enough time. Since it was my house, I was kind of doing a lot of running around, making sure everything was not broken and everybody was having a good time.
All right. What do you recall Ms. Anthony doing at your party?
She was taking care of my home while I was outside.
Okay. When you say taking care of the home, what do you mean?
Since I'm good friends with Amy, I let them to know that, just make sure nobody leaves the front door with a laptop or, the people in my home that I don't know, I'm out playing kickball. So she just pretty much took care of my home, stayed inside the whole day.
At the time, back in 2008 on July 4th, were you living downtown in Orlando?
Yes, sir, Thornton Park. Downtown Orlando.
Is that near Lake Eola?
Yes, sir, it's about 4 blocks away.
You may.
Sir, I've placed in front of you what's been previously marked for identification. I believe it's LH. Do you recognize that photograph?
Yes, sir, this is the picture I took on the way to Lake Eola.
Sir, the question is, do you recognize the photograph, yes or no?
Yes.
What is that a photograph of?
It's a photograph of Casey and Amy.
We would object to the witness testifying about a photograph that has not been admitted into evidence.
Overrule as to that question.
I'm sorry, you may finish.
It's a picture of Amy, Huizinga, and Casey walking to Lake Eola.
Did you take that photograph?
Yes, sir.
Is that a fair and accurate representation of what both Amy Huizinga, or how Amy Huizinga appeared as well as the defendant?
Yes, sir.
Your Honor, at this time, the state would move what's been marked for identification LH into evidence as the state's next in line.
What says the defense?
We would object as to relevance. It's cumulative, and we have additional argument. And prior disclosure.
Approach the sidebar. Okay, you may proceed.
Thank you, Judge. Again, at this time, the state would move what's been previously marked as LH for identification into evidence as the state's next in line.
It'll be admitted in evidence of objections.
May I publish this now?
You may.
Thank you, Judge. The person in the foreground or up front, is that Amy Huizinga?
Yes, sir.
And behind her is Caylee Anthony?
Yes, sir.
This was taken during the day of July 4th.
Yes, sir.
All right. All right, sir. Mr. Waters, during the course of the July 4th party, did you have the opportunity to speak with Ms. Anthony about her employment?
At the time, no.
Okay. Later on?
Overruled.
At the time, during the party, did you have the occasion to talk about her child?
She mentioned Caylee.
What did she mention about Caylee?
It was just a short, you know, I have a daughter, and I replied with a, yes, I do, Amy told me. And then that was left at that.
Did she say anything else about her daughter?
No, sir.
Did you go to the fireworks?
Yes, sir.
Who went to the fireworks?
We had a big group, mainly me, Casey, Amy, and just a bunch of random friends from restaurants in downtown.
While you were at the fireworks, were you near the defendant?
Yes, sir.
Did you continue to talk to her?
No, sir.
How come?
She was on the phone with her boyfriend at the time through basically the whole fireworks.
Based upon the conversation, did you hear the conversation?
Yes, sir.
What was Ms. Anthony talking about?
It was about Tony moving back to New York. I don't remember too much of it. I know just the baseline of it. It was just about moving to New York, and she didn't want him to, and I was really kind of focused on the fireworks. But
When the fireworks ended, did you see any change in Ms. Anthony's demeanor?
she was a little angry. A little angry.
Did she say anything to you upon hanging up with her boyfriend?
No, sir.
Overruled.
After the fireworks, where did you go?
We went back to my house, and everybody just continued to play games and drink.
What time did the party end?
Around 1:30, 2 o'clock.
After you came back from the party, what was the defendant doing?
Drinking.
Okay. Was she still watching over the house?
Yes, sir.
Did her mood change?
No, sir.
Was she still angry?
No, sir.
Okay. How was her mood when you got back to the party then?
Just,
Relevancy, Mr. George?
Your Honor, the defendant's state of mind during this time period and how she was acting is wholly relevant.
Excuse me.
It's not an objection.
carefree.
No, wait.
Oh.
Anything else, Mr. George?
No, sir.
Objection overruled.
What time did the party end?
Around 1:30, 2 o'clock.
At 1:30, 2 o'clock, when the party ended, was the defendant still there at your house?
Yes, sir.
When she left, with who did she leave with?
She left with Amy.
When they left your party, did you make any plans to see her again?
I got her phone number because I plan on going to IKEA the following day.
Did you tell the defendant that?
Yes, sir.
When you told her you want to go to IKEA, what was her response?
It was yes, that she would like to go.
Did you have a set time to meet?
No, sir.
All right, then let's move on to July 5th. On July 5th of 2008, did you see the defendant?
Yes, sir.
About what time did you see her?
Around 7:30, 8 o'clock in the morning.
Were you expecting her at 7:30, 8 o'clock in the morning?
No, sir.
Did you recall how she arrived at your place?
In vehicle or
In a
demeanor?
vehicle?
or-
Did she come in a vehicle?
I believe she had Amy's car.
What type of car did Amy have?
It was a blue Toyota Corolla. Red Toyota Corolla.
Did the defendant mention anything to you about why she had Amy's car?
Because there was something wrong with her car.
Was she specific about what was wrong with her car?
No, it was either the alignment or a tune-up.
All right. When she showed up, excuse me, when she showed up at 7:30, 8 o'clock, did you let her into your home?
My roommate did, I believe, because I was just getting out of the shower.
So what did you guys do?
She hung out upstairs, I got ready, and we went out shopping for the day.
All right. When she first came over to your house, how would you describe her demeanor?
spunky, good attitude.
Was there any indication from her demeanor that anything was wrong?
No, sir.
When you saw her on July 5th, did she tell you that her daughter was missing?
Overruled.
Can you repeat that?
Sure. On July 5th, when you saw her the next day, did she tell you her child was missing?
No, sir.
Did she tell you her child had been kidnapped,
No, sir.
that she was looking for her?
No, sir.
Did she ask you for any help in trying to find her?
No, sir.
Where did you go from your home?
From my home, we went to Target.
Who drove?
I did.
In your car?
Yes, sir.
Which Target did you go? Which Target did you go to?
The one on, I believe it's Kirkman, across from IKEA, the Millennium Mall area.
And what did you do at Target?
We got some coffee and some bubble gum. That's pretty much.
Did you purchase, or did the defendant purchase anything else at Target?
No, sir.
From Target, where did you go?
We went to, I believe we went to IKEA.
Have you ever heard of a restaurant called Zaxby's?
Yes, sir. That's where we went afterwards.
What is Zaxby's?
Zaxby's is a fast food chicken salad restaurant.
Overruled.
And you had lunch there?
Yes, sir.
Again, was there any change in the defendant's demeanor while you guys were having lunch?
No, sir.
From Zaxby's, where did you go?
Zaxby's, we went back to my house because she had to be at the airport at a certain time.
Well, after Zaxby's, you had mentioned something about IKEA.
IKEA was before Zaxby's.
How long did you spend at IKEA?
A good about 2.5 hours.
Why did you want to go to IKEA?
I needed to go to IKEA because I needed some picture for.
Relevance?
Not
We need to know why he wanted to go to IKEA.
Sustain.
Did the defendant want to go to IKEA?
Yes.
Okay. Did the defendant tell you what she needed to get at IKEA?
Yes, sir.
Overruled.
You can answer that question.
She was shopping for a bunch of furniture. It was her and a friend were supposed to be getting a house soon. Basically window shopping for that day.
What did she tell you about her living situation?
That her and a friend of hers that has kids were looking for a nanny, a stay-in nanny, so they were going to have their own house together.
Did she tell you this friend's name?
No, sir.
Did she tell you when she was planning on moving?
Within the next 2 months.
And that she needed furniture?
Yes, sir.
During this day, did you and the defendant have any conversations about her employment?
Yes, sir.
Did she tell you where she worked?
Yes, sir.
Where did she tell you she worked?
She was an event coordinator at Universal Studios.
Was she any more specific than that?
No, sir. Other than she just did a lot of work at home over her computer.
Did she mention the name of any coworkers?
No, sir.
Other than being able to do a lot of work from home in this job, did she tell you anything else about her employment?
Just that she loved her job.
That she,
Loved her job.
did she tell you how long she had had that job?
No, sir.
On July 5th of 2008, did the defendant ever mention her daughter, Caylee?
No, sir.
Did you ask any questions about Caylee?
No, sir.
All right, so was July, excuse me, was July 5th a good day for you?
It was a fun day, yes, sir.
Did you make any plans to see the defendant again?
At that time, no.
Okay. At any subsequent time, did you make plans with the defendant?
After a couple days after that,
Okay, what were the plans?
we were supposed to go take a, we were supposed to go out to dinner and take a helicopter ride. So I had some free passes for on I Drive.
Who was going to go on that helicopter ride?
Me and Casey.
Did you ask her to go?
Yes.
Did she agree?
Yes.
Okay. Did that helicopter ride happen?
No, sir.
What happened?
I texted her about 6 times and got no reply. And then I finally said, well, I'm here and I've got to let these people know because they're about to book the ride with somebody else. And she said she was tied up, and then it was left at that.
Did she tell you how she was tied up?
Something about a nana.
A nana?
A nana.
Did you ask her, did you know what a,
Go ahead.
did you ask or did you know what a nana was?
No, sir.
Okay. You said this, do you remember the date of that?
No, sir. I just know it was a Wednesday or a Thursday.
The Wednesday or Thursday after July 5th?
Yes, sir.
Okay, would that be July 10th?
Yes, sir.
Okay. After those plans canceled, did you have any other communication with the defendant?
A lot of text messaging throughout the days while I'm at work.
Now,
Text messaging.
understood. Did you, strike that. Did you ever see her again after July 5th?
No, sir.
Did you make plans with her to see her and they just didn't happen?
Yes, sir. We were supposed to meet up a couple times while I was at work at lunch, but whatever happened at work, meetings or whatever happened, we never really hung out after that.
She had meetings?
I had meetings.
Oh, you had meetings, okay. Directing your attention to July 12th of 2008, did you have plans to hang out or to see the defendant, Caylee Anthony?
One more time, please.
On July 12th of 2008, did you have plans to see or hang out with Caylee Anthony?
No, sir.
Were you aware that she had a boyfriend?
Yes.
I believe you testified earlier from July 4th. Your subsequent conversations, either on the phone or via text message, was it still under your understanding that she had a boyfriend?
Yes, sir.
Overruled.
Yes, sir.
Okay. Were you interested in Caylee Anthony?
Not really. I was in a breakup at the time, so really,
Sustain.
um,
Next question, Mr. George.
Yes, sir. Did you receive a text, I'm sorry, directing your attention to July 15th, did you receive a text message from the defendant?
I got a text message about 1:30 in the morning. Or actually, I got a phone call from an FBI agent.
Did you ever hear from the defendant on July 15th?
I can't recall. That was... no.
In any of those subsequent text messages after July 5th of 2008, up until July 15th, did the defendant ever notice you that her daughter was missing?
No, sir.
Overruled.
Thank you. I don't have any other questions, Judge. Thank you. Thank you, sir.
Cross-examination.
Good morning, Mr. Waters.
Mr. Baez?
I want to see if I understand. You had just met Caylee Anthony,
Yes, sir.
and as far as you understood, that the world that Caylee Anthony lived in was she had a job.
Yes, sir.
And in this world, she worked as an event planner,
Yes, sir.
and she appeared to really love that job.
Yes, sir.
She talked about it with enthusiasm.
Yes, sir.
And you realize that turned out to not be true, right?
Yes, sir.
Did she give you any indication that she was lying about her job?
No, sir.
Did she give you any indication that she didn't believe she had a job?
No, sir.
And part of this world also included that she was happy
Yes, sir.
and that there was absolutely nothing wrong in her life.
Other than the relationship with Tony, no.
Let's talk about that. That occurred on July 4th,
Yes, sir.
not anywhere near June 16, 2008. Is that a no?
Yes. No, it's a no.
Okay. Now, in addition to that, the world of Caylee Anthony that you knew was that she was going to move in with a friend, and that's Amy Huizinga,
No, sir.
another friend.
Yes, sir.
And they were going to bring their children,
Yes, sir.
and they were going to have a live-in nanny.
Yes, sir. Because it was cheaper that way than having two different nannies take care of different kids.
And she was going to pay for this nanny with this event planner job that she had.
I don't know how she's going to pay for it, but
And they went, and you guys went so far as to go shopping for furniture.
yes, sir.
Did she give you any indication that she was faking shopping for furniture?
No, sir.
In fact, you believed that she was going to get a place to live with a live-in nanny and a roommate.
Yes, sir.
Now, also in this world, you believe that Caylee was well, let me strike that. Let me ask you this. Caylee was friendly to you?
Yes, sir.
She was friendly to others?
Yes, sir.
She appeared to care for people?
Yes, sir.
In fact, she barely knew you and she was watching your place for you?
Yes, sir.
And you trusted her?
I trust a lot of people until you do something that's not right. Yeah, I'll trust anybody.
Did she make off with one of your laptops or anything?
No, sir.
Okay. Now, do you have any information about June 16, 2008, when Caylee drowned?
No, sir.
Do you have any information for this jury as to when Caylee died?
No, sir.
Do you have any information for this jury as to where Caylee died?
No, sir.
Thank you very much, sir.
Redirect.
Sir, if the statements that the defendant made to you about having a job and buying or getting a house with a live-in nanny were incorrect or lies,
Sir, do not answer the question until you finish asking the question. Finish asking.
based on your observations and the time you spent with the defendant, was she convincing?
Mr. Byers, you have an objection to that question? You can answer.
There was no reason to believe any different, so yes.
Thank you.
May the witness be excused.
Yes, sir.
Yes, sir.
Thank you, sir. You may be
Sir.
excused. State may call in next witness.
Your Honor, at this time, the state and the defense have entered into a number of stipulations as they relate to various videos from different locations dating from June 30th through July 15th of 2008. May I approach?
You may.
We stipulate as to the authenticity, but not, we still would require a foundation be laid.
You require foundation. Yeah. Approach the sidebar. Recess, we'll be in recess for 15 minutes to 10:15. Please do not discuss the case among yourselves, and remember all of my previous admonitions. Okay, Mr. Baez.
Yes, sir. I just wanted to clear up that the conversations at sidebar, I didn't have an opportunity to respond to Ms. Drain-Burdick. Everything she said was absolutely correct. Her and I have had multiple discussions about this, and she has been diligent in following up with me as it pertained to these stipulations. Our objection is one of relevance and lack of remorse under Randolph v. State. We don't think these are admissible under those aspects, under the law. And if the court is going to rule that this evidence is not reflective of lack of remorse and that they are relevant, those would be our objections and our standing objections, and we would not require anything further. When I give Ms. Drain-Burdick my word, it is my word, and I do not intend on revoking that in any way, shape, or form unless she's the first to know.
State any comments other than what you said before?
Only as it relates to lack of remorse and relevance. The videotapes themselves don't demonstrate Ms. Anthony's mood one way or another. They demonstrate her actions, and therefore they are relevant because they are all during the time frame between June 16th and July 15th to show that she was not looking for her daughter, as she informed law enforcement she was, that she was not basically moving heaven and earth to find out where Caylee Anthony was, as she informed law enforcement. And it is our position, as it was with all of the witnesses who testified to her activities, that the video of her activities, with or without a witness, is relevant as well.
I would just add one portion more to my objection, and that would be cumulative. I think we've had for an entire week witnesses testifying about her activities, that she was not searching for her daughter. It's been conceded by the defense, and to continue to go down this area is serving nothing and no purpose other than showing bad character.
As I indicated before, the evidence that the state has introduced at this time does not go to the issue of lack of remorse. It goes to show her demeanor. Some folks would suggest or argue that someone should act differently when they have lost a child to either kidnapping or death. And that is an issue for the jury to decide. There has been no testimony in this court estimation that violates the principles of Randolph dealing with the issue of lack of remorse. Lack of remorse comes in where someone who has murdered someone basically has no regrets or no remorse about doing that. That's not the purpose of this testimony, nor does this testimony reflect that. So the record would be abundantly clear. Anything else, folks? Because you got about 10 more minutes before your recess is over with. I'm looking at Jones versus State. Mr. Mason. And I think your the case you and I talking about must be different because this Jones deals with a photo lineup and the issue of a kidnapping charge. It does originate out of this court, and it was Judge Cohen who was the trial judge, and he can't. Okay.
It's my understanding from my brief conversation with Mr. Baez that they are not going to contest that it's Casey Anthony in the video.
I know that's what he just said, but that wasn't what he said at the bench.
I understand that.
Okay, we'll be in recess. Okay, let the record reflect that the defendant is present along with counsel for the defendant. We'll bring the jury back in, and what did I do with all the stipulations?
I would also add on the objections that we have to the videos, I think there's some where she's purchasing beer and alcohol. I think then becomes a 403 issue to add on to the others that we have. And again, I think that's showing bad character. And I think maybe the court might want to consider that before having them admitted.
Mr. George?
She was over the age of 21. I don't believe there's anything inherently wrong with buying beer.
Okay.
Well, that makes it prejudicial.
So I'll make sure that we're all on the same page. The defense is objecting on the grounds of relevancy, on the grounds that it shows improper character evidence. Any other grounds?
Improper state of mind
Improper
and lack of remorse.
And lack of remorse. But there is no objection to those being authentic, and that it shows the defendant, Miss Anthony.
Yes.
Okay.